The State High Court in Lokoja, Kogi State, where the former governor of Kogi State, Yahaya Bello, has been finding charges against EFCC for them not to arrest him, has now threatened to arrest the EFCC chairman, to issue the arrest warrant of EFCC chairman.
Kogi State High Court in Lokoja last Friday ordered the chairperson of the Economic and Financial Crimes Commission, Ola Olukoyede, to appear before it on May 13, 2024 to show why he should not be committed to prison for allegedly disobeying its order. Presiding Judge I.A. Jamil gave the order while ruling in a suit brought before him by a former governor of Kogi State, Yahaya Bello. Bello's application initiating a contempt charge against the EFCC chair is part of the former governor's efforts to stop his arraignment and trial on a charge of money laundering to the tune of 80 billion naira.
Do you understand what you just hear from Dr. Ruben Abati? Yes, the Kogi State High Court wants to issue a warrant for them to arrest the EFCC chairman. Now, people might be joking with this issue, or joking with the issue of court threatening to arrest the EFCC chairman. Now, I do tell people that the EFCC is for Yahoo boys and for people who don't have connection in politics. Yahaya Bello is still in Nigeria, and people are saying they don't know where he is and they can't arrest him. And they are flying court orders from here, there. Now, let me take you back to what happens in May 24, 2023. It's getting to a year now, about 10 months ago. The chief security officer seek Akpabio's probe over alleged 1 trillion fraud. Now, this was May 24, 2023. Now, what happened? When the former EFCC chairman, Bauer, wanted to start, prosecuting the Akpabio, immediately he became the Senate president. You know what he did? The first target was the EFCC chairman. They made sure that they sent him to prison. They arrested him. They charged him of, nonsense things. Tinubu said that the man was corrupt, that the man was not doing well. No, the man was haunting them. So that is why I'm trying to say that Nigerians should not just joke with what Yahaya Bello is trying to use Kogi State Court. I know that the FCC will always appeal to, higher courts like Appeal Court or to Supreme Court. But this is how they have been deceiving Nigerians and playing with Nigerians' emotions and intelligence. Before you know, the issue of Yahaya Bello will just vamoose. It will disappear from Nigeria news and you will not hear anything about that.
The Kogi State High Court in Lokoja last Friday ordered the chairperson of the Economic and Financial Crimes Commission, Ola Olukoyede, to appear before it on May 13, 2024 to show why he should not be committed to prison for allegedly disobeying its order. Presiding Judge I.A. Jamil gave the order while ruling in a suit brought before him by a former governor of Kogi State, Yahaya Bello. Bello's application initiating a contempt charge against the EFCC chair is part of the former governor's efforts to stop his arraignment and trial on a charge of money laundering to the tune of 80 billion naira. In the meantime, the Economic and Financial Crimes Commission has confirmed the receipt of the refund of $760,000 paid as advance school fees by former Governor Bello for his children at the American International School, Abuja. This was confirmed by a spokesman of the anti-graft agency Dele Uyewale. Earlier, the American International School in Abuja had asked the EFCC to provide what it called authentic banking details for the refund of fees paid by the children of the former governor. Fred Nziako is a trial lawyer and he now joins me. Good to have you here on This Day Live.
Thank you, Dr.
Mr. Nziako.
Good afternoon.
Okay, we took this subject last week on this program, but there have been more developments since then. Now the Kogi State High Court is charging the EFCC chairman for contempt. This is not the first time this will happen. We had a similar situation with Abdulrasheed Bawa when he was chairman of EFCC. Abdulrasheed Bawa just ignored the court. Now, of what effect is this charge of contempt by the Kogi State High Court. And what do you think is likely to happen? Is the EFCC chairman going to ignore the Kogi State High Court and say, well, they have a matter at the Federal High Court in Abuja?
I want to say emphatically that orders of high courts, that are courts of records, Supreme Court, I mean the court of records, should not be ignored. And because it sets a very terrible precedence, as if the country is a banana republic. Any country without laws cannot say to be a civil environment. And the judiciary has its responsibility as the third arm of government that will ensure that there are maintenance of law and order in terms of adjudication. And whatever the courts have said must be recognized, because anybody who has gone to court must submit to the adjudication of the court. And if agencies of government that are set by law, established by law, begin to breach the pronouncements of courts, which themselves are also set by law, then of course we are not moving the country in the right direction. The EFCC chairman should, and is expected to obey lawful orders of court. The order of court given by the Kogi State High Court, which is a court of record, to the fact that certain actions should not be done and certain actions should be done. And once, if anybody feels that such an order should not be, the rightful thing to do is to appeal such order. The High Court had given an order that Mr. Yahaya Bello should not be arrested, arraigned, harassed, and prosecuted without leave of court. That caveat is very important, because Yahaya Bello has gone to court saying that he is being persecuted, that he is being hounded unnecessarily and unduly. So it has always been back and forth between him and EFCC. And he said this thing started even while he was in office as governor. And that was when EFCC was arresting his appointees, arresting members of his State Executive Council on charges that they could not even substantiate. So, and EFCC was always insisting that they had issues against Yahaya Bello. And I will recall that in 2022 or thereabout, they went to court against the same government. And sometimes the thing got stalled. And even the matter that is now the issue now before the court is a matter that even started sometime in 2021. So, between Yahaya Bello and EFCC, the public is yet to know the truth. And the truth can only be said in the court of law, because one must say the truth in the court of law when you are under oath and when you have taken an affidavit to say the truth. But when you begin to give all manner of opinions in the public, sometimes even the social media, not even in the mainstream media, sometimes in the social media, the people get confused as to who is telling the truth. And that is why all eyes are expected all the truths are expected to come from the court, from the judiciary, so that we know exactly what is going on. Now the court is saying that the lawful order issued by the judge, Justice Jamil, is being flouted by EFCC. And of course the chairman should come and give answers to that.
The counsel to Alhaji Yahaya Bello said they got a restraining order on the 9th of February.
Yes.
Now, on the 17th of February, the EFCC, having filed an appeal against that order, then decided to storm Alhaji Bello's residence in Abuja. And Alhaji Bello's counsel is saying, why that order was still subsisting, it amounted to contempt for the EFCC to storm the residence even without a bench warrant. But you know the way the drama unfolded.
Yes.
The EFCC has since obtained a bench warrant on that same day.
On that same day.
Right, to correct whatever
which they said was obtained later in the day.
Subsequently, the Court of Justice in Wite has directed that a substituted service should be served on Alhaji Bello's counsel.
Yes.
Now, with those developments, with the substituted service being given and all of that, can Alhaji Bello still insist that he has not been invited?
Well, with the substituted service served on his counsel, he will no longer say he was not invited. But invitation by EFCC is different from the summons of court. This particular one is court summon. It's different from EFCC invitation, which of course EFCC was claiming that he was invited, and Yahaya Bello has said nobody ever invited him, and he's even challenged EFCC to publish to the public the letter of invitation. When was it delivered? Who received it? And all that. And of course, the public is yet to see that. So the general feeling of the public, and from the back and forth, is that Yahaya Bello was never invited by the EFCC, in which case the EFCC had not told the entire truth with respect to the invitation. Now, you are now talking about the summons by the court. That's a very different ball game. Yahaya Bello cannot say that he has not gotten the summons, since he has been served by substantial means through his counsel. Of course, his counsel is, except if he now says the counsel is no longer representing him in court. But since the counsel is still representing him in court, he has been summoned by the court. But the issue now, which is still hanging, is the issue of disobedience of lawful order of court, which is what has made the High Court to say that chairman of EFCC must show cause why he will not be committed to prison for contempt of court, because they went outside the order of court to lay siege on Yahaya Bello, and also went outside the order of court to do those things which the court said they should not do, pending the determination of the substantive suit. The substantive suit has now been determined. Meanwhile, EFCC went to Court of Appeal to challenge that interim order, and the matter was slated for hearing on 22nd of April, while the substantive suit now came out on 17th of April. So by 22nd of April, the suit at the Court of Appeal had become academic, and then they had to quickly withdraw that. Mm-hmm. So as at now, there is no appeal on that matter pending before the Court of Appeal. What we are now looking at is the substantive judgment by the High Court of Kogi State. And there is also another substantive judgment by the FCT High Court, which also surrounds the whole issue about payment of school fees and non-payment of school fees, which of course the EFCC also has some questions to answer. Bottom line, Dr. Abati, is we cannot build a country with this type of approach to law. Approach to law in the sense that you don't pick and choose which order to obey and which one not to obey. Every court that is set up by the Constitution as a competent court of justice must be respected. Because if you don't respect that, then we are not practicing civilian democracy.
Well, it's good you mentioned the part of the school. The school put out a statement.
Yes.
That yes, it's committed to providing service to parents and their students, but that the EFCC asked them to return the money. That, the $760,000 was a matter before the court. And the school said, well, being law-abiding institution, they decided to return the money. Now, do you think that the school acted rightly? Because Alhaji Yahaya Bello has also come forward to say that money has nothing to do with the resources of the state government. In other words, that would be a matter before the court, but it looks like the EFCC has gone ahead and collected the money without the matter being determined by the court.
The school wouldn't have acted rightly because there is a subsisting judgment, or rather judgment of court in that regard. The school went into an agreement, which they call the post-paid school fees agreement, something like that, in August 2021. All this are in the public domain, with not just Yahaya Bello, but his family. Because when the EFCC now pressed that they should return the money, the school, it wasn't today, they started pressing since 2022. The member of the family now went to court to bring an action against the school, asking the court to give declaratory orders so that the school should not, the money that I have received from my family, and go and pay it to a third party that is not part of that agreement. And the court gave a substantive judgment in November 2023 that the school should not pay that money to a third party. That is a subsisting judgment that has not been vacated, that has not been vitiated, that has not even been appealed against. Now, if the school went and paid that money to EFCC, that is a breach of the judgment of the court, in which case the school stands in contempt of the judgment of court. That is exactly what it is. And if the school is saying, oh, we are respecting agency of government or a certain institution of government, is the court not a recognized institution of government that deserves to be respected? If you place it on a balance between EFCC and the courts, which one deserves more respect? Which one is an arbiter in matters like this? EFCC is a complainant and should not be seen as a judge in their matter. So what the school has done is not only throwing away their own money, because as far as the Bello family is concerned, the school has just thrown away the money they paid to them, to EFCC, and the issues now begin to arise when they stop giving those children the academic training that for which the family has paid that amount of money for. But as far as the court is concerned, the school also stands in contempt and what they cannot be right.
Okay, but there's an aspect of this story that people have raised. Why should anybody pay school fees in Nigeria? Dollars. The national currency is naira. And there's been this concern about the dollarization of the Nigerian economy. Schools collect fees in dollars. Landlords collect fees in dollars. Luxury stores collect, denominate prices in dollars. Why? This is Nigeria. This is not the US. Why is it that we now use the dollar as legal tender?
I agree with you that dollarization is not healthy for our economy. As a matter of fact, that was one of the major reasons, one of the major causes of the demand push of the dollar. Because when people keep demanding dollar, it continues to affect the value of the naira as against the convertible currency dollar. And now people now begin to store dollar, not only using dollar as a medium of exchange, but as a store of value. It also affects the value in Nigeria. So I agree with you completely that it is wrong. It is a very wrong monetary policy, but we expected the government to put their feet on ground and ensure that unnecessary dollarization of the naira is stopped. And I believe that the current central bank governor is looking towards that direction. The current government is looking towards that direction. And I also believe that part of the reasons why the naira seems to be gaining some health and some balance in terms of value is because these actions are being put in place so that the unnecessary dollarization must stop. There's no reason or basis why schools will be collecting their school fees outside naira, in any currency that is not naira. But government agencies themselves should also stop doing so, except for people who are paying from outside Nigeria. Then that makes a lot of difference, but not within Nigeria. Take, for example, in the maritime sector, that is an international sector, and somebody is going to pay you, say, from outside Nigeria, the person will not pay you in his own country's currency, he can only pay in dollars. And that is where government should give an exception to that when they are talking about issue of dollarization. But for domestic transactions within the walls, within the geographical walls of the country, there is no basis or explanation or reason why naira will not be used, because that will save, not only save the value of the naira, but will also save the integrity of the country as a nation.
Okay, let's talk about jurisdiction, which is the fundament of legal processes in court. The counsel to Yahaya Bello is saying that the court in Abuja, the FCT High Court, is out of jurisdiction in this matter. Now, the EFCC counsel is also saying, no, the State High Court in Lokoja is also out of jurisdiction, that the EFCC is in Abuja, and the EFCC chairman is in Abuja. Why would the court in Lokoja be charging for contempt? So how do you think this matter of jurisdiction will be resolved with what now looks like two courts of coordinate jurisdiction,
yes,
acting almost as appellate courts over each other
on the same issue? Let's glean from the pronouncement or judgment of superior courts, the Court of Appeal. In the case of James Ibori, against EFCC against James Ibori, the matter was taken to Kaduna, the Federal High Court, Kaduna. The Court of Appeal gave a pronouncement that geographical jurisdiction must be considered because the actions happened in Delta State. The dramatic personnel were in Delta State. The state involved was Delta State. Why take the matter to Kaduna? That it is amount to dislocation the defendant, who will need the necessary environment to defend himself. Don't forget that it's a criminal matter, that trial must be seen not only to be seen, but to be judicially and judiciously conducted. And that has not been vacated. Of course, it follows natural reason and logic that a man should not commit an offense in Lagos and you go and be trying him in Sokoto. Agreed that Kogi State and the FCT have geographical contiguity, but they are entirely two different environments. Kogi State is a state on its own and FCT is different. So when you look at gleaning from that judgment of the Court of Appeal, you cannot be trying Yahaya Bello's matter in Abuja. Yes, EFCC is headquarters in Abuja, but there are branches all over. Otherwise, if you want to use that argument that is headquarters in Abuja, then why are you now looking into other issues outside Abuja? Since you have branches in all parts of the country, you can now begin to use your branch to conduct any process in any particular state. So I want to agree with that opinion that it is the High Court in Lokoja or the Federal High Court, whether the State High Court or the Federal High Court in Lokoja, that has the geographical jurisdiction to try this matter, and not the one on EFCC. But even with that, at the end of the day, what is now the issue now has become who has breached the fundamental judgment and the orders of the court, and who has kept it. EFCC is now seen in the eye of the law to be breaching the judgment and orders of the court, and that should not be.
Okay, with all of this, what would be your advice to the two parties involved?
Number one, my advice would be to the EFCC to start with, because this idea of media trial never fetches EFCC any judicial success at the end of the day, because what it seems is that EFCC tries to be a good agency in the eye of the public. A lot of Nigerian public do not know the nitty-gritty of trial that goes on in court. And they want to believe, once the EFCC has pronounced, oh, he has taken 80 billion, people will believe, oh, he has taken 80 billion. How come you are taking this kind of money when people are hungry? But the bottom line is, have you diligently investigated this matter? Have you gathered your evidence that will secure conviction in court, or you just want to make the razzmatazz in the public be seen as doing your work, and then you secure trial in the public opinion? But what of the trial where it matters most? The court does not go by the emotions of the public. The court goes by the strict evidence presented before it on all the issues. And if you don't have such evidence, there's no way you will secure conviction. And so many people also believe that the actions of EFCC is even giving out their intentions. Because when you over-dramatize and in a bid to satisfy the public, some of the things that you should have ordinarily used to present and fortify your logic in court, you will now bring it to the public domain. And of course, on itself, it's not even in tandem with judicial adjudication, because when matters are sub judice, you don't begin to grant unnecessary press conferences. We must learn this idea of by most other international agencies, security agencies, that will conduct their investigations discreetly, gather all the evidences, so by the time they confront any accused in the court of law, the accused will have nowhere to turn to. In this matter, the EFCC will just hold on one thing that is not firmed up and then begin to give conflicting stories to the media. And that is why the media team and the other teams of and supporters of Yahaya Bello are now saying that EFCC is misleading the public. The public themselves don't know the truth. They are waiting to hear the truth from the media. The EFCC will occupy the media space, then the defendants will now occupy the other side, and the matter in court is only the one where the court truth will be exposed. And until that is done, the public cannot continue to believe one side against the other. And on the side of Yahaya Bello, of course, he who goes to equity must go with green hands. If anybody, they said that clear conscience fears no accusation. Once he feels that the accusations against him by the EFCC are not cogent enough, he should go and have his day in court. And if he has cogent reasons to be free, naturally he will be free.
Well, on that note, Mr. Fred Nzako, I'd like to thank you very much for joining us